Ms. Graham.
Thank you. We were dealing with the press release that you issued just before lunch. Could we have that on the screen? COPFS 00975. So this is from October 2015 and it's listed here. Lord Advocate Frank Mulholland QC said, the investigation into the death of Sheku Bayo is being conducted by PERC under the direction of the Crown, and both are well aware of all the evidence, the lines of inquiry and the issues surrounding this case. The Crown and PERC are not influenced by comments made in the media, and that is how it should be. However, speculation and a running commentary on the investigation can be upsetting to the family of Sheku Bayo as well as the families of the officers involved. A decision will be taken at the end of this extremely complex investigation as to whether or not criminal proceedings should be raised. An inquiry will also be held at which all the relevant evidence will be heard open to the public and the media, and it is right that it is this forum where the evidence will be rigorously tested and judicially assessed. PERC and the Crown should be allowed to get on with their job. Do you see that? And that's where it ends. And if I can ask to go back to your first inquiry statement. And if we look at paragraphs 84 and 85. And you've been asked to comment on a statement from Mr. Johnson, Mr. Addy Johnson. He states that me calling publicly for calm and commentary to stop made the family feel that they were put in the same bracket as the SPF. 85. I was not intending to put the family in the same bracket as the SPF. In the media release, I stated, however, speculation and a running commentary on the investigation can be upsetting to the family of Sheku Bayo, as well as the families of the officers involved. I was not suggesting the family were leaking information and briefing the press. The terms of this media release is pored over by officials and the head of communications to get it right. I'm sorry if Mr. Johnson is upset by this, but in my opinion it could not have been phrased better. It was not directed at the family. And I think probably I missed the first couple of lines of the press release actually when I read it out. I wonder if we could go back just for a moment to COPFS 00975. I didn't read out the top line. The Lord Advocate has today called for restraint from all parties in the provision and publication of information in respect of the death of Sheku Bayo. So you call for restraint from all parties in regard to that.
Wasn't the family. It was not my intention. I never thought that the family were leaking information to the press. Never crossed my mind. Still doesn't. I don't think they were. And I was concerned about the family of Sheku Bayo and the effect it was having on them. And I was also concerned about the families of the officers involved. And it was the best of motivation to try and put a stop to it.
And was that your aim in speaking out in this way, which you said before lunch you'd never taken this step before?
Yep, that was essentially it. And if you just scroll down a bit, the Crown and PERC are not influenced by comments made in the media, and that's how it should be. I mean, there was one view that the information in the media was with a view to putting pressure on PERC and the Crown, so I just wanted to make that point absolutely clear. But there's reference to the family. It can be upsetting to the family of Sheku Bayo, as well as the families of the officers involved. I never crossed my mind that the family were leaking information to the press. I still don't believe it.
Looking at this press release with the benefit of hindsight, do you think it could have been phrased differently?
Well, the press release is, the point I was making is it's not just me. This is communications input and officials input. Maybe a call for restraint from all parties in the provision. All parties, what does you know, could that be taken as an implied criticism of families? Someone, all I can say, it was never intended that way, and it never crossed my mind.
So who was this directed to, this call for restraint?
Well, it was directed at the information that was appearing in the media, and I was hoping that the people that were leaking that information to the press would read this.
And were you aware of any particular source
Well,
of
I wouldn't like to say. I
information?
mean, I didn't know who was leaking to the press. It wasn't my business to find out, and if I tried to find out, then I wouldn't find out because of journalistic confidentiality, protection of sources and all that type of stuff. So it was pretty pointless even to attempt to find out. Did I know who? No, I didn't know. All I know was that there was information in the media, and it looked as if some of that information had been leaked by persons who knew. So that is, I mean, I could have written, you're right, I could have written to SPF and others, I don't know, but I thought that the best way to deal with this would be to deal with it head on and put this, and I did give consideration to this. And it had been raised by the family, and as I said to you earlier, it's very important that you listen to what the family has said, and I listened and tried to do something about it. It did, from memory, quieten it down somewhat, so I think it was the right thing to do.
Thank you. Can I ask you about some comments that have been made in another statement the inquiry has, a statement from Amar Anwar, SBPI 00549, and I'm interested in paragraphs 224 and 226. And this is Mr. Anwar. I have been asked what my or the family's expectations were of the Lord Advocate when we requested that he take action in relation to the media releases that the SPF were issuing. I think the family's expectation was that they would be robust with the Scottish Police Federation, whether it was material that they were putting in a public domain or whether it was letters they were writing to people, threatening them, or whether it was the media statements that they were making was interfering with the integrity of the investigation, that it was inflammatory, that it was prejudicing an ongoing live criminal investigation, whereas the Federation were just simply propagating the idea this was a fatal accident inquiry. That was a constant mantra. There will be a fatal accident inquiry at which all these issues will be discussed, almost excluding completely and utterly that there's supposed to be a live criminal investigation. Was it your recollection that the family's expectations of you was that you would be robust with the Scottish Police Federation in relation to their engagement with the media?
No, that's not my recollection.
So can you remind us, please, what was your recollection? Were the SPF included within that?
Well, they were
or
included with all parties, so all the people that were leaking, all the bodies, organisations leaking information to the press, it was directed at them.
But not exclusively to the Scottish Police Federation?
Not exclusively, no.
And can we look at paragraph 226, please? The family feel that the media has been used by the SPF to smear Sheku and attempt to bully the family into silence, to call them or their representatives liars, and complicit in this process has been Crown Office and PERC. Do you wish to make any comment about that suggestion?
Not the case for at my time when I was at the Crown.
Right. And just to go back briefly to 224.
But I mean, the family are entitled to express their views. If they thought that, they can express their views. But you asked me, is that correct? No, it's not.
And given the family's concern as is expressed in 226, do you consider there was anything more you could have done to address that concern?
I mean, I was absolutely committed to liaising, speaking, keeping up a regular dialogue with the family and the family solicitors. I was hoping that in that process it would give them confidence in the independence, objectivity of the Crown. Smearing, it's not my style. I know of, certainly my time with the Crown, I know of no one that would engage in that type of behaviour. And certainly there was no attempt to bully the family into silence. They had Amer Anwar acting for them. They had me. They could speak to me at any time. It needed to be arranged, the meeting, of course, but it was a regular dialogue with the family. And I would never thought, never called their representatives or them liars in any way. They were certainly not liars, and all I wanted to do was to help them navigate through a very difficult, distressing process for them that's not been of their making. They were thrust into this, and on a human level I wanted to help them.
It will of course be a matter for the chair, but it may be one interpretation of this paragraph that the concerns of the family are that SPF were attempting to smear Mr. Bio, bully the family and calling their representative liars rather than asserting that it was the Crown doing those things. Was that something that was drawn to your attention in relation to the SPF?
I can't say it wasn't, but I don't have a recollection of it. The SPF will need to answer for that themselves. I can't answer on their behalf. But the press release was designed that the people that were leaking this information into the press should be aware of it. And I earnestly hope that the press release would result in an end to this.
And specifically in relation to the concern that the Crown Office were complicit in this process, this smearing by
It's not
SPF.
the case.
And is there anything that you, reflecting on the events at this time, anything you can think of that could have been done by Crown Office to make it absolutely clear that the Crown were not complicit in these matters?
Well, I mean, you could make it clear directly to the family if you needed to. I didn't think that I needed to do that, and the Crown weren't complicit, weren't in any way smearing or complicit in smearing the family. I had great respect for the family, and I felt for the position that they were in, that had been thrust upon them. What else could the Crown? I mean, it's a matter of trust. Even a statement that we're not doing, if they don't believe it, then it's a matter for them, but it won't deal with it. What you've got to do is build up trust in how you're dealing with the case, with the investigation.
And if we can go back briefly to 224, the paragraph we looked at a moment ago, where the family's expectation was that you would be robust with the Scottish Police Federation. I'm interested in the comment at the end of that paragraph. The Federation were just simply propagating this idea this was a fatal accident inquiry. That was a constant mantra. There would be a fatal accident inquiry at which all these issues will be discussed, almost excluding completely and utterly that there's supposed to be a live criminal investigation. I'm interested in this aspect of the family's impression that there was perhaps an overemphasis, if I can put it that way, on the FAI rather than the live criminal investigation.
Well, I mean, I can't speak for the family and what their perception is, but I can reassure you it was a live criminal investigation, and in support of that, I think in the documentation that certainly I was shown, I instructed Les Brown, or the investigative team, to speak to the Health and Safety Division of the Crown Office and also the Health and Safety Executive, to place them on notice that in addition to individual criminality, we're looking at systemic criminality under the Health and Safety at Work clause, and I think there's documentation I've seen to confirm that that was carried out. The Health and Safety Executive said that thank you very much, we'll keep a watching brief. So what I was doing was ensuring that the relevant Health and Safety Unit of the Crown Office and the investigators, Health and Safety investigators, were placed on notice that they had an interest. I had years ago prosecuted Transco. I knew health and safety law in great detail. I'd set up the Health and Safety Executive, or Health and Safety Division in the Crown Office to bring expertise in health and safety matters. There's also reference, I can't put my finger on it just now, but from what I've read, in PERC had obtained standard operating procedures, training, the extent of training for police officers in restraint, arrest techniques, deployment of sprays, and all that was of a view to being in a position to assess that aspect of the criminality. And what I do is I use that as an example to point out that this was a live criminal investigation. It was mandatory to hold an FAI. That's parked. That will happen. But this is about a live criminal investigation. That's all about reassuring the family, reassuring the public that this has been extensively, properly investigated. But if it was just to facilitate a fatal accident inquiry, it could have been done in months, quite frankly.
I think there may be an issue about whether an FAI was mandatory in terms of the legislation, but I think from your perspective, as I understand your statement, it was anticipated that there would be a public interest in holding an FAI.
Well, I saw it as mandatory. It's a death in custody.
And as I say, that may be the position that there is a disagreement about whether this was truly
whoever
a death in
disagrees, I was Lord Advocate. I saw it as a mandatory fatal accident inquiry, at the very least.
And at the very least, it is a death following police contact. And
well, it was in custody, was it not? That's the point.
That'll be a matter for submission.
Well, a matter for submission. I can tell you how I saw it. I saw it as a death in police custody.
Talking about the Health and Safety Executive, we've heard evidence, and there's other evidence available to the Chair, that the Crown and PERC would have welcomed the involvement of the HSE in relation to this matter. The HSE declined to engage in the investigation. And I'm interested in evidence we've heard that it's not open to the Crown to direct the HSE to investigate. If they decline, that is the end of the matter. I'm interested in any perspectives you have about whether that is something that the Crown would have wished to pursue if they'd had the power to do so.
Well, I'll go back to Transco and the debrief coming out of the Transco trial. I made the point that it would be helpful to have the power to direct the Health and Safety Executive, and that was fed in. And I can't swear to this. I think there was some correspondence with either the Health and Safety Executive or the UK government with someone who was a looker or who had responsibility for this area, and it was decided to leave things as they are.
Was this at the time of Transco?
Post the debrief coming out of Transco.
All right, thank you. Can I ask you to look at another paragraph in your statement, 476, if we can go back to that, and look at paragraph 124. You were asked about a handover of the investigation between you and your successor, Mr. Wolfe. And you say, I spoke to James Wolfe by telephone and reiterated the importance of this inquiry, including the need to maintain good and regular liaison with the family. I'm interested in your recollection of that telephone conversation.
Well, I've a very good recollection of the telephone conversation. I can tell you how it came about.
Please do.
Having been appointed as Solicitor General and then Lord Advocate, I know from personal experience that on taking up office there is a lot of detailed briefing which is provided to the new law officer by senior officials at the Crown Office. I remember when I first took up post as a law officer, that briefing took the best part of a week. It's not only the Crown Office in relation to criminal matters, it's also SGLD, Scottish Government Legal Directorate, in relation to the array of civil cases. So, and you also get briefing from the Crown Agent about, I've forgotten the phrase now, it's about treasure and various other matters. Cramming line comes to mind, that fines that the public makes. So there's a vast array of briefing. It's quite onerous actually to go through it. It's very detailed. And officials are there to present it, explain it, you can ask questions. So when I demitted office, first thing I did was to hand the BlackBerry in without deleting anything, and handed that over to the Crown Agent. What I then did was my personal mobile, I gave the number of that to the private office and said to the private office that if James wishes to telephone me about anything, just pick up the phone. If I'm not available at that time, I promise I'll get back to you. 3 weeks into James's post as Lord Advocate, he phoned me. I was at home, it was in the evening, and the call took about an hour. We went over, I gave James advice, a lot of advice as to what to look out for, how to deal with certain situations, about Cabinet, his attendance at Cabinet, about dealing with the Crown officials. I mean, James didn't have the background that I had, that had worked for the Crown for 30, 40 years. So I wanted to be as helpful as possible to him. Including in the telephone call, went through a number of high-profile cases. Sheku Bayou investigation was one of them. And I said, look, James, you really need to ensure that you maintain good, regular liaison with the family. I described the family, where they were from, and how to deal with it, and I suggested that he dealt with it personally to ensure that the family know that it's been dealt with at the highest level. There were other matters which are irrelevant to here, but it was a lengthy conversation, and what I wanted to do was to help James in his new job as Lord Advocate, and that was an important case which I didn't go into the evidence in detail, but I did mention the liaison with the family.
And when you described good and regular liaison with the family, did you give any indication of what that had been, how that looked under you?
Well, in the general conversation, I'd be talking about the meetings that I had with the family in Amir Anwar. And I think, although I can't swear to it, but I think I would have said I met with them around about every 2 months or so. I may have mentioned that. But I didn't go into detail in there. That's not my business to go into the evidence. one, because we didn't even have a final report at the time, and two, the Crown really hadn't embarked on its own investigations. I wanted them to know that it was important, because I knew it was important. And James, being a new Lord Advocate, it was important to him as well, and I didn't want him to be on the receiving end of criticism for not doing that job. And I wanted to ensure that the family continued to be helped.
Thank you. Can I ask you about the use of the word reiterated? You reiterated the importance of this inquiry. Can I ask why you selected that word, or did it mean anything beyond?
Didn't really.
No.
It's just, I suppose, my words.
Is it essentially you emphasise the
Yeah,
importance?
that's essentially what it meant. I think, from recollection, James was very receptive to that, fully understood that. So I tried to help James as much as I could.
Thank you. Now, can I go back to one thing that you mentioned earlier before lunch regarding the interim or PERC report, the first PERC report that you received? You had that in August 2015.
Yeah.
And you talked earlier in your evidence about you hadn't read the appendices.
No.
But you'd read, did you read the whole report? Or?
Well, I can't swear to, I certainly read the narrative of what happened. I certainly read the pathology, and there'd be introduction and that type of stuff.
We've heard that this was a substantial document, over 350 pages in length. There was no reference in that document, however, to race, racism, discrimination, racial discrimination, anything of that sort. Not even to raise it and exclude it, although it was recognised that Mr. Bio was a black man. Did you notice when you reviewed that report that was missing?
No, it didn't stick out. As I've said before, race was front, left, centre. We're alive to it. This was an interim report, the final report still to come in. So it wasn't particularly, it didn't stick out. I wasn't concerned about it. Nobody drew that to my attention. I just was under the impression that in the final report, which would be more comprehensive than the interim report, would be dealt with.
Was it not something that you noticed, given your views on the importance of race and race being front and centre, or race being at the heart of this, that it was it not noticeable by its absence?
Well, I knew from Les Brown conversations, correspondence, that race was under investigation, given examples of that, so I just assumed that as an interim report that race will be dealt with in the final report. So no, I didn't have a concern about that.
Are you saying there was correspondence you had from Les Brown that said race was under investigation?
Well, there was, I think I referred this morning to the letter from Les Brown to Jim Fleming.
So I am interested in the period up to the first PERC report, which was August 2015. So in that period, from the death of Mr. Bio on the 3rd of May 2015 up to August 2015, 7th of August, when the PERC report, first one, was sent to the Crown. During that period, as the evidence we've heard indicates that the first time race was mentioned by the Crown in correspondence with PERC was dated the 2nd of September 2015, so that's at a later date. That's after the first report.
Well, I mean, I can only tell you about conversations and my perception and the perception of senior lawyers at the Crown Office, including Les Brown, and in conversations with PERC, that race was front, left, centre.
Certainly, we have evidence that there were meetings between you and, as we said earlier, Kate Frame and John Mitchell, and you've talked about conversations with PERC regarding race and the importance of race. Did it not strike you as odd that race wasn't mentioned in the first PERC report?
It didn't strike me because it was an interim report or whatever terminology. You know, I've dealt with a number of interim reports on various matters. It's the final report that matters. And if there's any deficiencies in the final report, then they'll be highlighted because the Crown's got a duty to investigate it as well. If there's any deficiencies in the PERC investigation, then that should be remedied by the Crown, and instructions to PERC to do X, Y and Z and release the investigation of race if they've not dealt with it. So at that stage in reading that report, no, it didn't strike me as particularly unusual or noteworthy.
Did you have any hand at that stage in instructing Les Brown to address the issue of race with PERC to make sure that this wasn't being left out of account?
Well, it was my understanding that it was being addressed through Les and the Crown team, and I'd made absolutely clear, I didn't need to make it clear that race was an issue, you know, right at the heart of this. So I mean, the journey through this, from day one, the people in the Crown, including myself, knew this was the key issue in this, absolutely critical, along with other issues. I don't want to say it was this and the only, along with the other, but it was absolutely the key issue as far as I was concerned, and as far as Les Brown, Lindsay Miller, and others working on it. And conversations with PERC, discussions with PERC through Les and my discussions. I was under no misapprehension that PERC were ignoring race. It was my impression that they knew it was an important issue in the case. So when I read the interim report, it didn't strike me because I knew that my understanding that it was being investigated by PERC.
Could you give me a moment, please? Thank you very much. I have no further questions.
Lord Mulholland, can you help me with one thing? Taking you back to the first issue that you discussed this morning, which was the issue of disclosure of expert reports and the like to the family, and the difference of approach between you and your successor, Mr. Wolfe. And one point that you made in the context of Mr. McGowan's minute was that Mr. McGowan and James Wolfe were dealing with a different situation. The final report was in, and the Crown was now doing its precognition preparation. When I made the decision, it was a different set of circumstances. Can you explain to me what the significance of the different stages is?
Well, the different set of circumstances, the fact the final report's in. So it's now under the Crown for investigation. So that's a different set of circumstances. And at that stage, the Crown will review what the evidence is, review the expert evidence, review whether further experts should be instructed. And at that stage, so that's different from the stage that I dealt with, was before the final PERC report had been received, and indeed before the interim report was received. So that's what I meant by a different set of circumstances. I don't know their thinking at the time that Steve McGowan's minute and the Lord Advocate, James Wolfe, Lord Advocate, made that decision. I can only tell you how I saw it. I saw there was little prejudice to potential criminal proceedings, and I took the view that to facilitate the family solicitor instructing their own experts that I should do that.
And if you had still been the Lord Advocate by the time the Crown were preparing the recognition, would you have changed your position as a result of the changed circumstances?
I would only have changed my position if there was a particular reason to do it. I would have kept the undertaking I gave unless I could rationalise a change in approach, a change set of circumstances or something of that nature.
Thank you.
So it's difficult to project yourself because I'd stepped
I
down at the
appreciate
time.
that.
But
Now, are there any Rule 9 applications? Miss Mitchell, nobody else. Lord Mulholland, would you
yes,
mind withdrawing to the witness room while I hear a submission?
okay.
Yes.
I just have one issue that I would like to raise, and it relates to some evidence the inquiry has heard into the murder of Simon San. As the inquiry will have heard, Lord Mulholland in writing gave evidence about this matter, and he also gave evidence today at the hearing. He spoke on whether or not the Crown considered the matter racially motivated, and he explained about placing information before the court about the family identifying it as a racist matter, even though the Crown did not do so. And just for the purposes of the inquiry, it's at page 53 of the evidence and following. In writing at paragraph 24 of his statement, which is recorded by my learned friend again this morning, reading it out, the question was whether the crime was racially motivated. The answer on the evidence was that it was not racially aggravated. We made sure that the information was placed before the court. We also ensured this was fully explained to the family of Mr. San. So again, you raised a number of issues here. This was a case that you yourself prosecuted, was it, or involved? And then he said it wasn't. He didn't think he was the person who had presented it. And my learned friend goes on, right, you've talked about their placing the information before the court and explain the purpose of that. And what it said is, well, there's a number of purposes. Firstly, it's to allow the court to give the court the information so they can take it into account in sentence. Secondly, it places the information in a public, I'm not sure how that's been translated, domain, thank you, a public domain, so that the public, the media and the family are well aware of it. So it's not expressed, not hidden. It gives accountability, public accountability, in the sense that this is your assessment of the evidence and allows anyone who disagrees with that assessment to challenge it, to make it known, challenge it in writing, for example, or whatever. Now, unfortunately, the report, so what happened after this hearing is that Lothian and Borders, who were the police service dealing with the case, did a year-long review of their involvement in this matter. And I'm now reading from a newspaper article saying what the outcome of that was. And I've passed these on to my learned friend. The newspaper article on the 23rd August 2011 indicated that after a year-long internal inquiry overseen by Deputy Chief Constable Steve Allen, Allen confirmed that the force should have treated Mr. San's death as a racist murder. And then he goes on to make various different further apologies. After that time, it appears, but on the same day, the Crown Office issued a statement indicating that it was alert to the question of racial motivation from the beginning of the investigation, and after careful consideration of all the available evidence provided to the Crown by the police, Crown Counsel concluded that there was no evidence to show that the attack on Mr San was racially motivated. Thereafter, it appears at some point Mr Anwar called upon the Lord Advocate to, some point in that day, called upon the Lord Advocate to itself carry out a Crown inquiry in relation to the handling of the case. And there seems to be an additional press release by the Crown. It said, addition to CO statement 23rd August, we can confirm the Lord Advocate will not be instructing an inquiry and is satisfied with the Crown's prosecution of the case. Mr John Logue, the Area Procurator Fiscal for Lothian Borders, has offered to meet with Mr San's family to discuss any questions which they might now have. After that very long explanation, for hopefully I won't have to go into that detail with the former Lord Advocate, but after that very long explanation, what I would like to ask is whether or not, why he didn't call for an inquiry into the way the Crown Office had dealt with the issue of race in the present case of Mr San. And I say that's important because this inquiry has evidence before it that Crown Office were trained in respect of issues of race. This was an incident that happened relatively soon before the incident in this case, and that might have been an opportunity for the Crown to engage with the matter and consider it. In particular, as it's quoted in one of the newspaper articles, it might have saved another family in the future from having to fight for answers from the authorities. And I just would like to ask if there was a reason that there wasn't an inquiry, given the very clear distinction between the year-long investigation and what Lothian Borders had identified and what the Crown Office position was.
Yes, very well. I shall allow you to ask these questions. Can we have the witness back, please? Lord Mulholland, Miss Mitchell, who's Senior Counsel for the families of Shekubayo, has some questions for you.
Okay.
Miss Mitchell.
It just relates to one issue that I want to ask you about, and in fact it's about the case of Simon San, which you referred to earlier in your evidence. And you gave evidence this morning. The question was whether or not the crime was racially motivated, and you said the answer on the evidence was that it was not racially aggravated. And then you went on to explain about the Crown having put evidence about what the family thought in front of the court, and that allowed that to be made public, as it were. Do you recall that after Mr San's case was in court, there was an investigation done by Lothian and Borders Police into their handling of the case?
Very vaguely. When I say there was the crime wasn't racially motivated, what I mean was that there was no evidence that the crime was racially motivated. There's a fine distinction there. But to answer your question directly, I've got a vague recollection of it, so I couldn't give you chapter and verse as to what it involved.
Do you remember the outcome of that
No.
inquiry? The outcome of that matter was that after a year-long inquiry by Lothian and Borders Police, Deputy Chief Constable Steve Allen confirmed that the force should have treated Mr Sands' death as a racist murder. And he apologised to the family and explained various different things that were going to be done by Lothian Borders Police in respect of that. And one of which include the force's procedures being significantly overhauled. At that time, there was a call by Mr Anwar asking the Crown Office for it to review its handling of the matter. Do you recall that?
No, I don't.
No.
I'm not saying that didn't happen, but
Well, there
don't
definitely there
recall
appears
that.
to be a Crown Office release about it.
yeah,
so-
well, I don't recall it's the answer to
Okay.
that. But in relation to the prosecution, we were dealing with what the evidence was at the time.
Yes,
Evidence
indeed.
available at that time. Lothian Borders Police had an investigation. Am I right in thinking that was post the criminal prosecution?
It appears to be so.
Yeah. So that the findings of that wouldn't have been available at the time that the case was dealt with, disposed of.
Oh yes, indeed. It was a year later.
Yeah,
I don't suggest in any way that the Crown could have gone back and revisited the prosecution issue. What I'm wondering is whether or not, in light of that finding, that after a year's investigation, Lothian Borders Police took the view that they ought to have dealt with that in that way, and the Crown was asked by Mr Anwar to review its practices and procedures.
I
what-
don't remember that.
You-
I'm not saying it didn't happen, but I don't remember that.
Indeed, what appears to be said in a document online, and again, in fairness to you, you don't have it before you, but perhaps in a future hearing that might become available. But this document purports to say we can confirm the Lord Advocate will not be instructing an inquiry and is satisfied with the Crown's prosecution of the case. Mr John Logue, the Area Procurator Fiscal for Lothian Borders, has offered to meet with Mr Sands' family to discuss any questions which they might now have.
What was the date of that?
That appears to be 23rd of August 2011.
Right, okay. Well, John Logue's now the Crown agent. So that means, from what you tell me, that was looked at in some detail to generate that response. I can't speak to that because I've no recollection of it. I need to see the paperwork, and that may jog my memory, but I genuinely have no recollection. I remember there was a bit of a furore at the time that Deputy Chief Constable made certain statements. I think he gave a Newsnight interview, if I remember rightly.
Well, you know more than me in respect
Well,
of that matter.
there was a bit of, let me put it this way, without knowing the intimate details, there was a bit of controversy about what was said.
Yeah. But in any event, the Crown didn't conduct an inquiry.
Well, I think it's confirmation of that in the statement, but I can't explain why, because I can't remember. I need to see the paperwork.
Well, that may be something that could be done.
Yeah.
I'm obliged.
Okay.
Thank you. Lord Mulholland, thank you very much for coming to give evidence to the inquiry. I'm very grateful for your time. When the inquiry adjourns, you'll be free to go.
Thank you.
That brings this hearing to a close, though it is likely that some further evidence in relation to the subject matter of this hearing will be introduced at a later stage. The next hearing will begin on the 4th of June 2024, when the inquiry will hear evidence, including evidence in relation to the issue of race. My assessors and I, and the inquiry team, are very conscious that tomorrow is the 9th anniversary of the death of Sheku Bayo. And we know and understand that each anniversary is a difficult and distressing time for members of the families and friends of Sheku Bayo. I want to take this opportunity to recognise the continuing commitment of the families to the inquiry, and I renew the commitment of the inquiry to a thorough and independent examination of the evidence. The inquiry will now adjourn.